Welcome to Employment Law This Week. I'm George Whipple. Our top story, California Governor Jerry Brown has signed 2 new laws that impact the hiring process. A ban-the-box law that restricts when employers can ask job applicants about criminal history, and a salary history ban that bars employers from asking job applicants about their salary history or using that information in setting compensation. Both laws align with nationwide trends, with states, cities, and counties all taking action. California's salary history ban comes on the heels of New York City's similar law, which takes effect on October 31st. We asked Ann Knuckles Mahoney to compare California's new law to New York City's.
In California, employers will be required to provide, upon reasonable request, a pay scale to applicants for the position. While the New York City law certainly contemplates having discussions about salary expectations, this requirement to affirmatively provide a pay scale is certainly something different from the other salary history inquiry laws. Another key difference is that this California salary history law reaffirms part of the California equal pay law, which prohibits employers from justifying salary discrepancies based on prior salary history alone. Additionally, the New York City law allows employers to ask applicants about their deferred compensation and pay equity that they may be giving up in order to change jobs.
The FLSA requires employers to pay workers for breaks of up to 20 minutes, the Third Circuit rules. Employer Progressive Business Publications allowed sales representatives to log off their computers and take breaks whenever they chose, and for any length of time. But if the workers were logged off for more than a minute and a half, they were not paid for the time. The panel gave deference to the DOL Wage and Hour Division's interpretation of compensatable breaks, concluding that treating breaks longer than 90 seconds as unpaid flexible time flouted the spirit of the FLSA. A draw-pay system for commission-paid employees may be legal, but not if terminated workers are required to repay advances. The Sixth Circuit will let a proposed class of sales employees move forward with their wage and hour suit against appliance retailer H.H. Gregg. The company advances sales employees a draw to cover any difference between their commissions and the minimum wage for their hours worked. The employees are required to repay the draw from their future commission earnings. The court found that this draw and commission system is permitted under the FLSA, but allowed the workers to move forward with their claim that requiring repayment of draws following termination violates the FLSA. The 11th Circuit says certain ERISA time limits can be waived by the employer. The question arose from a DOL action against TPP Holdings for breach of fiduciary duty. During settlement negotiations, TPP agreed to waive a timeliness argument in exchange for a delay in filing the action. After settlement negotiations broke down, the DOL filed suit, and TPP raised the timeliness defense anyway, arguing that ERISA did not allow the parties to waive the statute of limitations. The 11th Circuit disagreed, stating that rights of all kinds, even constitutional ones, can be waived. October is Diversity Awareness Month, and we're participating with diversity-focused tips all month. This week, Keith Early, principal at Early Interventions LLC, shares his thoughts on avoiding diversity stagnation.
There are 5 things that we can do. First, focus on the business case, which is often articulated but not well executed. Second, the hiring process versus the retention process. If we focus more on the culture and on leadership commitment and accountability, then we have a better shot at reducing turnover and improving our hiring. Third, white men are diverse. Excluding white men from the definition of diversity sends a message that diversity is not about them. It is, but from a different vantage point. Fourth, strengthening accountability. If we can enhance the financial incentives that are tied to diversity, then we have a better shot at impacting the success of diversity efforts. We should not confuse activities with strategy. Strategy promotes measurable progress and accountability. It ensures that key committees or departments all have a role in diversity outcomes, and therefore it is systemic.
Thanks, Keith. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.